These are 10 important clauses that must be present in your agreement for you to feel safe. Welcome to Education, our weekly legal podcast, where we break down legal issues, legal topics to your understanding without having to go to the law school. All right, before we go into today's discussion, I have good news for you. November is a very important month for us at Chazon Legal. First, I was called to bar in the month of November, and Chazon Legal started as TM Adeyemi and Co. in the month of November, and we rebranded to Chazon Legal about this time last year. And so, because of that, we are celebrating it with a free business webinar for our community. You can clap at this point. Okay, if you're a business owner or you are planning to start a business soon, we are giving you this free gift in form of a free business webinar. We are targeting just about 50 business owners, and we want to take you through how to navigate the business landscape in Nigeria using the instrumentality of the law. All right. The details will be on the screen, and you will also find it on all our social media platform. The link to register for this business webinar will also be placed on all our social media platforms. We will be expecting you to be there. Now to the business of the day. There are very important clauses that must be present in your agreement before you can feel safe as a party in that agreement. I'm just going to go through them very quickly. Number one is that agreement must specify the parties to the agreement. Who and who does this agreement bind? There must be a reciter. That reciter is what gives a background to that agreement. What led to what before you came to the point of doing this agreement. There should also be definition clause where you define specific terms, because what a word may mean in the ordinary term may not be what is intended to mean in that agreement. So it's important that you define those words in the definition clause. There must also be a consideration clause. What is the consideration for this agreement? Now, the word consideration, we have discussed this in our last video. You can check our last video to be able to understand what that means. Consideration clause. How much what is the contract sum, or what is to be done as a form of exchange, or as a form of value being exchanged in this agreement. Obligation and rights clause. This is the main part of the agreement. It is that clause that defines the rights, the obligation of each party. Party A should do this. Party B should do this, and all of that. And this is the basis where you can actually bring an action for breach of contract when somebody breaches. You must also have a duration or term clause to define, this agreement is going to last for 1 year. This agreement is going to last for 3 years. This agreement is going to last for 5 years. And whether it's going to be renewable and under what condition it will be renewable, it is very important that that agreement must have the termination clause. Everything that has a beginning must also have an end. And for some reason that peculiar to everybody, when you enter into a business relation or contractual relationship and all, you may have reason to want to back out. You may have a reason to want to terminate that agreement. But that must be defined, or the process must be defined in your agreement. How do you need to give a notice? What is the duration of notice that should be given, and other conditions before any of the parties can validly walk out of that agreement? The next important clause is confidentiality. That agreement, you have to define whether one of the parties can inform the whole world about your agreement or the content of your agreement and all. But because it's usually business related and all, and there are secrets that are exchanged, there are very vital personal information that are exchanged during negotiations and all, it is important that there be a confidentiality clause in your contract, because humans, and in every relationship, there will always be, or there is the chance that there will be dispute. It is also very important that you put in your agreement a dispute resolution clause. How do you intend to settle any dispute if and when it arises? Do you want to go to mediation? Do you want to submit it to arbitration? Or do you want to go to court? Whatever it is, you should state how your dispute should be resolved. You also need to define which law is going to guide your contract. Let me say generally, there are no statutes, there are no specific laws that regulate contracts generally. There are issues that have to do with individual. So you have to now define which law or which law should govern that your contract, which, our contract is going to be governed by the laws of Nigeria, or our contract is going to be governed by the laws of America, our contract is going to be governed by the law of the You need to define which law you are submitting your contract to. Your contract must also have a clause. This is to protect each of the parties. We call it force majeure. And what that means, or what that does in your agreement, is to also define that when certain things occur that are beyond each of the party, for instance, act of God, like maybe there is war, there is natural disaster and all of that, and it is impossible for any of the party or each of the party to perform their duty or their home part of the contract. How should this be treated and all? That must also be there to protect you. If not, whether there is war or not, you'll be expected to perform that contract, and that may be unfair to you. Lastly, you should also define whether that contract is the entire contract, or there are also other contract, mini contract that can be incorporated into that agreement. I'm sure you've learned a lot from today. Well, if you have done that, please try to subscribe, share, like, and ensure that you also register for a free business webinar. Thank you.